Friends, we are starting now. Today is 156th Friday group meeting. The topic is fundamentals of the law of wills. The speaker is our beloved L. Narasimha Reddy garu, senior advocate, former Chief Justice of Patna High Court and Central Administrative Tribunal chairman also. Now he joined in the bar. He has practiced lawyer and judge. Then after that, now thank you very much, sir. 11th hour I catched, he immediately agreed, his favorite subject, civil side. Sir, without wasting anything, sir, just he will read, Rahul Agarwal read your CV for a minute. Rahul, please.
Very brief.
Yeah.
Absolutely. Yeah. Sir is a postgraduate in law from Osmania University, practiced in the High Court of AP from 1979 onwards, became the government pleader for the state of AP, standing counsel for the Osmania University and senior standing counsel for the government of India. Sir has elevated as a judge, High Court of AP in September 2001, disposed of more than 1 lakh cases in all branches and nearly 3,500 judgments were reported in national and state law journals. Sir has functioned as Dean, Faculty of Law, Osmania University, Kakatiya University and Telangana University. Sir was appointed as Chief Justice of Patna High Court on 2nd of January 2015 and retired on 31st of July 2015. During this period, functioned as ex officio Chancellor of Chanakya National University, Patna. Sir was appointed as one-man committee on one rank, one pension and submitted the report. Sir has been the chairman of the committee to review the working of Dakshin Bharatiya Hindu Parachar Sabha and submitted the report. Sir has been the president for Keshav Memorial Education Society, Narayan, Hyderabad since 2004. Sir is appointed as Chancellor University of Hyderabad and Sir has been appointed as the chairman of Central Administrative Tribunal.
Good evening, esteemed brothers and sisters. It is my privilege to be here and to share some of my views on a subject in which my ignorance is a bit limited. When G.Seshagiri Rao, our old friend, indicated to me that I need to speak on this occasion, I was in two minds. It needs a lot of preparation, particularly when the audience is esteemed and highly learned people. But at the same time, I wanted to avail the opportunity of meeting all of you on this occasion. All of you are very well acquainted that accrual of property, whether movable or immovable, happens to be one of the most important aspects in anybody's life. That accrual takes place either voluntarily or involuntarily. Voluntary is where one purchases the property, takes it on lease, exchange, mortgage and all that. Involuntary is where the property accrues to a person by operation of the personal law or by that is known as intestate succession and by way of wills, which is testatorily succession. Now, all of you are aware the other forms of transfer are governed by the provisions of the Transfer of Property Act, and the intestate succession by the respective personal laws, and this testate succession, which we call mostly by wills, it is governed by the provisions of Indian Succession Act. So one typical feature about it is, as between testate and intestate succession. Intestate succession commences with the birth of a child, that is from the cradle. In contrast, testate succession through will operates on the death of the testator, that is, it speaks from the grave. So one starts from cradle, the other starts from the coffin. That is the substantial difference between these two. Now, how a will is to be made, that is also provided in detail by the Indian Succession Act itself. The first and foremost requirement is that in case of Hindus, it should be only in respect of self-acquired property and not ancestral property. In respect of others, the law differs. There are also some restrictions as to the applicability of the law of the succession through wills and all that in respect of Muslims. I do not intend to touch that subject at all. Now, making of wills, ordinarily only a person with sane mind or some of the features which are dealt with under the Contract Act also apply to this. Most importantly is about the method of signature and that of attestation. How it is to be signed is also provided. First, before that, what is a will? What are the typical features of a will is dealt with under Section 2H of the Indian Succession Act. It says the legal declaration of the intention of a testator with respect to his property which he desires to be carried into effect after his death. So these are the 2-3 typical features of a will. Now, here itself we need to refer to a definition of codicil. Codicil is, suppose a will is made already and the testator intends to add something or to modify it. Then what is the procedure? Then there again it is defined under Section 2B as an instrument made in relation to a will and explaining or altering the adding to the distribution or part and distribution of the properties, and this invariably forms part of the original will itself. Now, as to the making of the will, Section 59 mentions about the capacity of a person to make a will. Then, before dealing with the method of making will, the Section 61 provides for the circumstances under which a will can be treated as void. That is, when it is obtained by fraud, coercion, threat and all that, or wherever there are other suspicious circumstances which need to be explained later. Now, the making of will is provided for in detail under Section 63. The first requirement is the testator shall shine and affix his mark by someone, or sometimes he may authorize someone else to do it on his behalf. Now, one important provision that is contained there itself is that the signature or the mark of the testator shall be in such a way that it should indicate that the signature is put only for the purpose of will. This is in a way to avoid the use of existing signed papers for the purpose of the writing or executing the wills. So the place and the method of signing is also given prominence in the context of making of the wills. Mere existence of sufficient signature is not sufficient. Its place, if it gives an indication that the paper on which the signature exists was meant for something else, then it becomes a serious and strong suspicious circumstance which needs to be explained. Now, more important in this is about the testation. The will is required to be attestation. Many a time, both the persons who execute or those who try to put it in operation do not maintain the distinction between the signing by witnesses on the one hand and attestation on the other hand. Attestation is not defined as such, but it is a description is provided for under Section 63 itself, 63C. Incidentally, Section 3 of the Transfer of Property Act also provides for the manner in which an attestation is required to be made. Because under the Transfer of Property Act, we out of the 5 basic and principal kinds of transfers, that is sale, mortgage, lease, exchange and gift. Gift is required to be attested. If the gift is not attested, it cannot be treated as valid. Registration is another aspect, but attestation is made compulsory in respect of gifts and Here, in case of wills, what is attestation? All of you are aware. Please keep in mind that I am only putting some of my views, and I am confident all of you are invariably, each one of you are more learned than me. It is only exchange of views, that's all. Now, attestation, it should be attested by at least two witnesses. How? First, they should be present or seeing the testator or the person making the will signing up on the document. They should first see. Sometimes the testator may authorize some third person to sign on his behalf, whether when he becomes either paralytic or not being in a position to sign or being illiterate. If he authorizes someone to sign on his behalf, the testators must be present when either the witnesses, the attesting witnesses must be present either when the testator himself is signing it or when the person authorized by the testator puts his signature or mark on that. That is one thing. Sometimes the will is already signed elsewhere, so it was not attested at that time. In such cases, the attestation can take place where the testator vouches for his signature, saying that I signed it, or the persons whom he authorized, they also come and inform the attestors that the gentleman has signed on some occasion, and once the testators are satisfied that the signed signature contained on the document, that is will, is genuine, they put their signatures on the will, that is attestation. The same attestation is provided for in case of the gift also under the Transfer of Property Act. Now, it is not necessary that both the witnesses must be present at the same time. It can take place, one attesting witness can sign at one time, and with some gap or time, another attesting witness can also sign it. Now, as I said earlier, the will speaks from the grave of the testator. Therefore, the lot of difficulty exists and arises in the context of proving the will. The normal practice is whenever a document is executed and it is required to prove, the foremost requirement is to examine the person who executed it. Here the gentleman is not available. Therefore, the principal requirement is to prove it through by examining the attesting witnesses. The attesting witnesses are put to strict proof about them, and they must satisfy the court that the will was executed in their presence or in the manner provided for under law, and they attested the will. Now, sometimes it may become necessary to go for some other method when the attesting witnesses are not available, or either one or two of them have died. The law in this regard is laid down by the Honorable Supreme Court in 1969, 1 SCC 573, the initial case, and thereafter recently in 2010, 5 SCC 234. Now, in case of death of one or two attesting witnesses, the persons who have seen the attesting witnesses signing the document, that is, attesting witness was required to be present when the testator signed it. If the attesting witnesses are not available by the time the will is required to be proved, then the persons who incidentally were present when the attestation was taking place can also be examined as witnesses instead of leaving the matter at large. That was provided for recently. Of course, earlier cases were also there. Recently in 2018-15 scale, page 323, the Honorable Supreme Court declared law in that regard. Now, under Section 90 of the Indian Evidence Act, we find that inference can be drawn in respect of documents which are more than 30 years old. In such cases, the degree of proof is rather lessened, but in case of wills, no such inference can be drawn, even if they were of more than 30 years old. Inference does not arise at all. That was clarified by the Supreme Court in 2013, 7 SCC, page 490. There is some conception or difference of understanding as to the effect of registration of a will. Unlike other documents, a will is generally registered by putting it in a sealed cover and entering it to with the registrar's office. The contents are not made known nor entered in the register, because if they are entered, the very significance is lost. Once the contents of the will are known to others, quite many problems arise. Therefore, registration will not make anything things much different, except that the existence of will, distinguished from proof, the existence of will can be inferred from the factum of registration. Beyond that, the registration will not add any strength to the will. It is required to be once again proved as provided in law. So, just we have seen the proof about execution. Execution is whether two parts, whether the testator was the one who signed it. Secondly, the attestation has taken place as required in law. If these two things are proved, the factum of the execution of the will can be said to have been proved to satisfaction of the court. But that is not the end. The most important part of it is the very concept of will it deviates or sometimes obliterates the very process of succession, the flow of succession. If the properties of the testator or the person who made the will were to accrue to his legal lineal descendants or legal heirs, then will was not tested at all. Will is resorted to only when he wants his property to go in a form different from the law of succession of that particular community or the religion. Then, if the legal heirs are omitted from the purview of the will, or omitted from the distribution of the properties under the will, that happens to be one of the suspicious circumstances. The heavy one, there are other things also which need to be taken care of. There are other suspicious circumstances. For example, the health of the testator at the relevant point of time, or his proximity or absence of it from the persons on whom the property was bequeathed. Then the court has to, or the person who is objecting to the will can simply say that there was no possibility of the will being executed in these circumstances. That, for example, the family is otherwise all right. Relation between the family head or the testator on the one hand, and rest of the family members are very cordial. Then when such is the case, if the property is bequeathed on some third person, then strong circumstance must be pleaded. How is it that he referred the third person to the members of the family who are close and dearer to him? Normally, such instances take place when there was some dissensions or lack of amity between the family members, or if he availed better services from a third person or third family, whatever it is, on whom he has bequeathed. In the absence of those things, a strong suspicious circumstance arises which needs to be explained by the persons who claim benefit under the will. There are other things also. A will can be another suspicious circumstance is where the signature is in a trembling, or it appears to have been put with a trembling hand, or unnatural. If the signature available or undisputed signature of the testator is compared with the one on the will, that also can be proved. It falls into it answers two categories, that is proof of the will and the dispelling or explaining of the suspicious circumstances. The suspicious circumstances are many, and as I said once, the exclusion of lineal descendants, and absence of any special reason to deviate or exclude those who are near and dearer to him. But these are all questions of fact. Each case has to be dealt with on its own basis. So the burden always rests upon the propounder of the will. Propounder is the one who claims benefit under the will. Then that is shaky signature, then the ill health of the gentleman who did it, the exclusion of the natural heirs. These are all provided for, and some of them are described by the Supreme Court in 2010 5 SCC page 770. Now, revocation of will. Once a will is made, it is put in a form or with some third person or whatever it is, and once it is done, it has to operate. But is it all? Once a will is it a final document or all that? Then there are many exceptions to it. One is where the testator marries after the execution of the will. That itself is sufficient to put an end to the will. Because after the marriage, the structure of the family changes. Then either legal descendants or successors according to the personal law, they come to be changed. So the law provides that the marriage of a testator will put an end to the will executed by him earlier. Second is if he has executed a subsequent will, then the earlier will stands revoked, and that revocation sometimes can also by necessary implication, though not by executing a separate and independent will. If he has taken steps, for example, he bequeathed an item of property on the beneficiaries. Then that very property has sold or did something else. Then also the earlier will loses its significance. Then that is provided under section 60, 69 and 70. Now, alteration or obliteration of the wills. Suppose he can, having executed a will by providing a particular manner of succession, he changes his mind. He doesn't want it to be revoked, but he wants to add or subtract something. What is the procedure to be done? There, by the same means, he has to add or substitute anything, and sometimes a will may have been revoked. Once he may have revoked it by executing a separate will or by simply making a communication. But by change of mind, once again, he wants to revive the will. What is the procedure then? Then the law provides under section 73, any other form of communication will be of no use. If he wants to revive, maybe with the same contents, he has to re-execute the will in the same manner as is required for making of the will in the first instance. So there is a revival also, but revival can take place only in accordance with the procedure of making the wills in the beginning itself. Now, I am only trying to put before you some fundamentals. It's a vast subject where even days together will be needed to go into details of it. Now, construction of the will. How to construe a will? Because the original intention cannot be gathered that succinctly on account of the absence of the person. Then it is, for example, in the process of describing a property or a person, the testator takes recourse to a particular method. He calls the property, suppose the general name of the property is one thing and he calls it with a different name. Or sometimes the beneficiaries also, he names them in such with his understanding, but in reality they are slightly different. Then mere existence of such a slight misnomer or difference as to description would not put an end to the will. The will does not become void on account of that. Once the main intention is there, slight difference as to the description, either of the property or of the persons, can be gathered and the will can be put to legal operation. Then, if there is any ambiguity, law provides for the taking of the aid of extrinsic or external evidence also. With the help of the evidence, it can be put into operation. For example, in the section itself, some illustrations are given. He says half of the property shall go to the elder son of my first son or first daughter by name, some name, either Rama or Krishna or whatever it is. Then it emerges that the first son of his elder son is with some other name, some kuch Bhaskar kuch hai. Then does it mean that it should go waste? No. Once they say he may have felt maybe on account of age or misinformation, whatever it is, he may have given some name. But once the basic facts, that is, on whom he wanted to bequeath the property, he should be the first son of his eldest son or eldest brother, whatever it is. So eldest brother is certain. Then who is the next person, next to link? The eldest brother's first son. The first son, whether with whatever name he may have called, that description is full, therefore it can be put into operation. Then but the will becomes void. There is nothing like voidable for the will. Either it is void or valid. Unlike in the Contract Act, there is nothing like voidable. So a will becomes void if it is made in favor of a non-existent person. The person mentioned in the will does not exist at all. Then it becomes void. One cannot say he may have made this. We can substitute some other name. It automatically becomes void. Now, there is a typical concept also in case of wills. Of course, it sounds like redemption. Redemption is in case of mortgages. In case of wills, it is redemption. Redemption is where the will is executed and everything is all right. Property is identified and persons are identified on whom it will be bequeathed. But it so happens that by the time the testator dies and will is to be operated, the property does not exist at all. Then there is no other go. One cannot say, the beneficiary cannot say the property used to exist earlier and it has been grabbed by somebody, I will be able to recover it. That is not permissible. The requirement is that by the time the testator died, the property must be in existence. Even if a few days before his death, the property either was seized by somebody or it ceased to exist on account of whatever reason, then the concept of redemption comes into play. Redemption is where the will loses its significance and it becomes inoperative. So then it will lose its value. Therefore, in the process of making wills, these are the basic. There are many other details also about the prerogative wills. Prerogative wills are those which are required to be executed by persons in the armed forces or soldiers. For them, the procedure is different. The attesting and all that will be in different form. That also may not be that much. Only in rare instances at the time of war and all that, where the person is not able to have any contact with his family members and all that, he may take a decision, and for that a different procedure is prescribed under the section prerogative will see. Maybe section 74 or so. So much of the litigation in respect of wills is about the two things. First is about attestation, the second is about explaining away or dispelling the suspicious circumstances. If these two are done, then as I said earlier, most of the times either the persons assisting the testator or others, they do not maintain the distinction between the signature by witnesses and attestation. Attestation, at least in two cases, that is gift and the wills, both are involuntary transactions, and one property devolving or accruing to a gentleman from another person who is neither connected through legal succession nor for any consideration. So for those two type of involuntary accruals of property, law requires and insists on attestation so that the documents are not easily brought into existence to knock away the properties. So friends, these are my basic views on our fundamentals, views on fundamentals of this. There is scope for explaining it much more, and I am confident that you also are aware of much more than this. And it is a very good practice or good gesture to spend our time discussing something which is common to all of us. I am very any question answers.
Yeah, what? Friends, only one question or two questions allowed. He has to leave another 5 minutes. Thank you very much. 3:30 already. 3:30. It's 32 in fact. So, please. Yeah, you remove that and focus that.
Blind man making will, and also about the joint will by the husband and wife mostly.
Yes. Blind man, there is a provision in that section that is making of the will. See, 63. If you read section 63, madam, it provides not only for signing of the will by the testator by a person, but also by a person authorized by him. So the blind man can authorize a person to sign on his behalf. So,
But if the blind man knows how to sign,
then he can sign it. That signature should be
Attested.
before the attestors.
okay.
If he signs it before that, it need not be signature. It can even be a mark. It can be either thumb impression or the blind. They have got Braille lipi.
Yes, yes.
Braille. They can do it in Braille, but that should occur in the presence of attesting witnesses.
So some people because of diabetes they become blind like after the age of 50.
Yes. So
They knows how to sign.
So they can they can put their signature and the attestors can. The attestors must be before them. Or if it is signed already, the very person can tell them that I have signed it on so and so day. This is my signature. Then
The second part is about the joint will. What are the precautions we have to take?
joint will as good as any other thing.
If one of the partner dies before, then there are some precautions with it. It shouldn't be challenged. What are the precautions we can take?
That too, it will not. See, will does not become operative till the second man dies.
Right.
Then man or woman, it can't be. So
What are precautions
it
we
will
can
lie till the other man dies. It can't be enforced in part.
Sir,
Yeah, please.
just to the addition, can we put a clause there in the will just to protect that if this is going to be the final and conclusive will? Can we put a clause
Even
like
if you write a full one-page note saying that the last and final will, you can put an end to that with 2 words. I revoke the will. That's all. If later stage, if you say that I revoke the will, end of the matter.
Muthu, please. Just focus.
Contingent will valid. In the sense, condition precedent, if I execute a will with the condition precedent, in that on performance of certain act, this will becomes operative. Is that valid?
Yes, that can be done. You can put it, but it should not be to the exclude. There is a separate chapter on that. The burden on the legatee, that is the beneficiary, should not be more and at that time there will be a chance of election. In the sense, the legatee can choose either to receive the bequeath in its whole or to abandon it.
Yeah.
Sometimes, as you said, they contingent with they shall pay rent out of this property, or from this our sources they shall make donation to institutions, or all those things. It is for the beneficiaries to choose.
Please, just completing, sir. 340 is already, friends. Now we are,
I thank each one of you for patiently hearing whatever I have said. My only request is, if you find something relevant in this, keep it. If you find something not relevant, press the delete button. End of the
yeah, please. One minute. Thank you. Thank you very much, sir. You have explained very nicely. Time is very precious. Friends, we have a part 2 also. We'll see appropriate as far as convenient, and leisurely we can ask so many questions, and detailed we can have. So thank you very much, sir.
I thank G.Seshagiri first and all of you, and I am really happy that such things are taking place. Each it is a continuous learning. Continuous learning, and tomorrow you may be able to find something defective in what I said. That itself is also big learning.
Thank you.